Well, on Wednesday, December 1st of 2021, the Supreme Court heard what's called the Dobbs case. It's perhaps the most significant challenge to Roe versus Wade in the last 30 years at least. And that's what we're here to talk about tonight. You know them, I know them. ERI are an amazing organization. And tonight we're going to have some of the folks at ERI kind of just unpack what was going on at those oral arguments. We're going to look at a whole bunch of information. I'm really excited about this. My name is Tim. I run a YouTube channel called Dealing with Deconstruction. I'm also the executive producer for 1 Minute Apologist and an associate pastor at Image Church in Charlotte, North Carolina. But most of all, I am a friend of ERI, just like you are, and I'm excited to be hosting this discussion that Emily and Andrew and Josh are going to have around this extremely pivotal case. I know I said that wrong, but you know what I mean.
This happened in the pre-show too.
I know. But I think one of the things that I wanted to make sure that if you are a pro-lifer and you want to be less weird, that you subscribe to this YouTube channel. If you're on Facebook checking us out, go ahead and share this out to your network. We would love for more people to see this. And if we're going to be trying to take questions, and so if you have a question, you can leave it in the chat, put a Q there, and that will let me know that you have a question that you would like the panelist to answer. So without further ado, I'm going to go ahead and hand it over to Josh, and we're going to get started with this amazing discussion.
Thanks so much, Tim. It's so good to have you doing this. It is so good to not be running the tech for a live stream. And I've already said I'm never going to do it again without Tim Hull running everything because it is so much better. So this is clearly a really important case. I want us talking about it. Here's basically what we're going to do. We're going to talk a bit of background. I'm going to assume that some of you did not listen to the oral arguments, all of that. I'm going to assume that some of you don't even know, really know exactly what is going on with Dobbs. So we're going to have Andrew come on. Andrew Kaake is our lead editor. He's our lead philosopher at ERI. He's our lead research guy. And Andrew, I want you to come on and explain the background of Dobbs. Why are we sharing my screen?
Oh, no, there you go.
Oh, there you go. I want to talk about the background of Dobbs and the questions that the Supreme Court is considering in this case. Talk about some key terms because they're just terms like Starry Decisis and Reliance Interest. That it's like if you don't know what that is and you're trying to listen to the oral arguments to make sense of it, it's not going to make a lot of sense. So I want you to do some background information, and then all three of us are going to talk through what happened in the oral arguments and kind of catch you up. We were all listening live. We took a lot of notes. We've got a lot of thoughts. We kind of tried to trim it down to the most important stuff. But want to kind of let you know what at ERI, what was our reaction and our thoughts, and what are some of the arguments or responses that we think the pro-lifers can make in their own dialogues when people are talking about this. And then finally, of course, we'll have a Q&A session. So Andrew, take it away. Talk about this Dobbs case and the questions that the Supreme Court is considering in this case.
Absolutely. So, Dobbs v. Jackson Women's Health Organization. The Supreme Court finally took it up after a wait which seemed like forever. I think it was a little over a year before they granted certiorari, which is to say before they agreed to hear the case. So the law at issue in the Dobbs case is a 15-week ban on abortions. So what that means is abortions up through the 15th week are permitted, generally speaking, but after week 15, except for in case of life of the mother or I believe fetal anomaly, there are no abortions allowed. And so this case is this law is designed to clearly butt into the viability standard in Kasich v. Planned Parenthood. And so when this brief was originally presented to the Supreme Court, the state was asking them to overturn the viability standard in Kasich, but not necessarily to overturn Roe and Kasich. They kind of slipped it in a footnote. They said, by the way, we think you should overturn Roe. But they weren't pushing for that at first. And then later rounds of filings with the case came on. And then they kind of realized, hey, we have an opportunity here. And so they expanded much more and really pushed for, well, first you should overturn Roe, you should overturn Casey, but if you don't, then we're still asking you to remove the viability standard and uphold the law under Casey. So that is the basic background of Dobbs itself. And then there are a bunch of terms. And that's going to get really fun because these terms are themselves things that are contested. Like, these are the things that are at issue in the case. And if you listened to the oral arguments, a lot of the reasons why the lawyers and the justices were saying things in the way they were saying them, or asking certain questions, were because of the way that these key terms kind of play in with the jurisprudence of the moment. And so the first thing I want to talk about is Starry Decisis. Simply put, Starry Decisis means to let a judgment stand once it's been decided. And what that means in practice is the court doesn't want to hear the same case over and over again and be expected to produce a different result. If the court has said, we rule X in situation Y, they don't want someone to come back in situation Y the next year and say, yeah, you ruled X there, but we want you to rule Z now. And so Starry Decisis is a general principle of law that's been around going back to English common law. However, Casey introduces a specific test for Starry Decisis. And so there are four main features of the Casey test. First, if something, or so to back up for a moment, something needs to meet it. I think all four of these under Casey to consider overruling. So first is the central principle of the case at issue unworkable? So in this case, the central principle that people are talking about in Casey, particularly the counsel for Jackson and the counsel for the United States, is abortions up until the point of viability. So is that principle unworkable? The second feature is what's called a reliance interest. Since this law has passed, or this decision was made, how have people come to rely on the decision that was rendered? And the idea is, if more people are relying on this in a certain way, then the justices should be especially hesitant to overrule it. The third thing is whether or not the law has kind of moved on, if the case is an anachronism now. And then the fourth is whether there are changed premises of fact. And what they mean by that is, are the facts of the case really the same? Or has something changed in the intervening space that should make us consider whether the facts stated in the original case were really as they were stated? So, for example, the history laid out in Roe about abortion in the different states has been debunked pretty significantly since. And so that could be considered a changed premise of fact. And then the other feature of Starry Decisis under Casey, a special fun one, is what's called super Starry Decisis. And it's the idea that especially important cases or watershed cases should have to meet an even higher bar of consideration before you should throw it out. And so Casey states that there are only 3 cases that meet that level, and that Roe is one of them. And so they in the Casey court, the decision of the court is that Roe is such an important precedent that there should be an even higher standard to overturn it. So I want to move on from Starry Decisis to one of the points of Starry Decisis we talked about, which is a reliance interest. And so reliance interests, I said before, are the idea that you've come to rely on a certain thing. It can't be dispositive on its own, and we'll get into that a little bit more later with some of the back and forth between the justices and the counsels. But the idea is you don't want to take away a right that people have come to depend on. You don't want to take away this thing they've based their lives around. So it should mitigate against overturning something if that's kind of a bedrock principle or if overturning that means other things are going to be called into question, or there'll be a million more court cases. Another important term to know is undue burden. And so the test created by Casey, when it moved away from the framework of Roe, the trimester framework in particular, and the strict scrutiny standard that was used to evaluate regulations on abortion under Roe, is what's called the undue burden test. And this is important because people are using it wrong. Even the counsel for the state, I believe, is kind of misusing undue burden here. So undue burden under Casey, and I'm following Sharif Girgis here, I believe, is the idea that you can constructively ban abortion without saying we've banned abortion past a certain point. And so if I say every OB-GYN performing an abortion in the state of Mississippi has to have a PhD in religion and medical ethics, just so that no one can do it, I've constructively said, well, no one can perform one legally, so you can't get one, but I haven't banned abortion.
Right.
And Casey, with the undue burden standard, says, well, we're going to recognize that for the nonsense that it is. You can't block abortion without blocking abortion. You can't just kind of do the smoke and mirrors. And so undue burden is the test that they use to evaluate whether a regulation is a legitimate exercise of state power or whether they're just trying to ban abortion. But the reason undue burden is strange in this case is because it's not really an issue of undue burden. It's an abortion ban. It is banned after 15 weeks. They're not trying to burden the procedure. They've banned the procedure.
Right.
And then the last thing to touch on, which many of you are probably already familiar with, is the concept of viability. And viability is really important because Casey decides that viability is the central holding of Roe. And therefore it becomes, in some ways, the central holding of Casey in upholding Roe. And so viability is the point. The justices are using 24 weeks. There's some question whether it should be a little earlier or not. We've had, I believe, the fetus delivered at 21 weeks survive at this point.
Yep.
So there's some wiggle room. But 24 weeks is the placeholder that they've been using. But it's the point at which an infant has some expectation of surviving outside the womb or can survive outside the womb. And it is, when we talk about personhood arguments at ERI, viability is the squirreliest one because it's the one that moves. As we have better science and better technology, we are able to care for premature children in NICUs with a far greater degree of success and earlier and earlier than we were before, which is part of why the trimester framework in Roe is so unworkable, is because, well, viability is not 27 weeks. Now it's much earlier. And so it's also used within the abortion jurisprudence of the court as a tipping point at which the state interest in preserving the fetus's life finally catches up with the woman's interest in her own autonomy, liberty, privacy, and we'll get into which one of those is what's doing the heavy lifting later. So that's kind of the background. I'll pass this one back to you, Josh.
Yeah, that's super helpful. And so let's, having done all that, then let's talk about what happened yesterday, because a lot happened. It was more interesting than even I thought it was going to be. So let's work through some of those things. So one of the things that happened was the argument was made that, hey, the pro-lifers shouldn't win here because nothing has changed since Casey. Basically, this is just Casey again. So you need a better reason to overturn than I think Casey was wrong. And the first point that the person working kind of on the pro-life side, Stewart, the first point he made was about fetal pain. And what's interesting was, he's like, we've got this new science and kind of knowledge of fetal pain. And then Justice Sotomayor argued that only a small fringe of doctors believe that fetal pain begins before 20 weeks. And so he does this thing there where he talks about how, okay, So, and Stewart had mentioned like the idea of like, well, now we can see that the fetus sometimes recoils, and we think maybe that's pain. And Sotomayor, I thought, made a legitimate point here. This is why when pro-lifers talk about fetal pain, that shouldn't be the way that you talk about it, because I think she did a pretty good job of taking that down by saying, look, that can happen. Biologically speaking, you can have people in comas. You can even have dead people for a while whose bodies kind of do that thing. Like that can happen, which is true. As he said, that doesn't prove pain or consciousness. What I couldn't believe was that nobody brought up the relatively recent fetal pain study that sort of like functionally overturns all the previous fetal pain studies. So up until recently, most doctors who had studied fetal pain, which is a really hard thing to study, like really hard to figure out what is happening when, what is this kind of automatic muscle flinching, what is not, it's not the easiest thing to figure out. And so up until recently, most doctors would say 24 weeks. There were a few that were saying, there were some that would say 20 weeks. And then recently, and Secular Pro-Life has a couple of great blog posts about this that we'll post in the comments, but there's a new article called Reconsidering Fetal Pain. And this is in the Journal of Medical Ethics, and it's by Stuart Derbyshire and John Bachman. Here's what's super interesting about this piece, is that Derbyshire's pro-choice, okay? He's a pro-choice researcher who publicly has argued that fetal pain could not begin before 24 weeks. He's argued that for, decades, I think, basically. And then John Bachman is a pro-lifer. He's a teacher, and he specifically emails directly Dr. Derbyshire and is like, I'm not convinced by some of your arguments. And so they start like this back and forth. And ultimately, it results in this new study where Derbyshire is refuting himself. He's basically saying there are reasons to think that fetal pain could begin as early as 13 weeks. And that I was wrong before, that there are things that we hadn't considered in all the previous fetal pain research. I couldn't believe that nobody brought this up, because that is new. That was a couple of years ago that came out. And I think that would have been really relevant. The U.S. Council also maintained that everyone in the U.S. understands Roe. Was I don't Andrew? I don't know if this was you.
Yeah,
or if this
that was me.
Was this you? Okay.
I heard that, and I was just like, well, that was the most easily falsifiable claim of the day.
Not everyone in the U.S. understands Roe.
There are so many polls in which you tweak the wording just a little bit. If you ask about Roe, people support Roe. If you ask about what Roe actually states or the holdings of Roe, people don't support that. That seems to indicate that there is not a one-for-one matchup in people who understand Roe and people who support Roe. I do want to move back just a little bit. So first of all, I thought, I was hoping, as you were, that that the counsel for Dobbs was going to, or the counsel for the state was going to bring up this new fetal pain study. I wonder if he was trying to, before Justice Sotomayor basically called all early fetal pain work pseudoscience. But then she's also relying on brain death as her criterion of death for her whole argument that you can respond to stimuli after death, which brain death may be moving out within medical ethics, but that which is another new fact of the case.
I mean, so I understand. I think it's a legitimate point that like Stewart might have been like, even if he's got like the new fetal pain research study like in his back pocket, and then Sotomayor is like, only French doctors believe in this. Still, the fact that a pro-choice researcher who just up until recently was being like quoted and testifying for Planned Parenthood is now saying, no, it might be as early as 13 weeks. Like, wait, you're going to call your own guy pseudoscience now? Like, why was he not pseudoscience before when he was arguing for 24 weeks? Like, the thing that you believe, Sotomayor, is based on, partially this guy's own research. So you can't just call that pseudoscience.
Also, there's this idea that if it's a minority, they're fringe. Well, the other label for a very small minority in science doing good work is cutting edge. And they are on the cutting edge of the science. and that's why it's fringe.
That's a great point. That's a great point. Okay, go to the next. Go to the next thing and kind of explain this idea about precedent.
Okay, so one of the big points of conflict is what it takes to overturn a precedent. And this is partially problematic because Casey says, well, you need these 4 things and then maybe extra sauce to overturn an important precedent. But a lot of the justices, and especially Alito in particular, were kind of pushing back on this. They were trying to push the counsel for Jackson and the counsel for the U.S. and see, well, do you really need these 4 factors? Do you really need changed facts of the case or something like that? Or can you overrule a case because it's clearly wrong? Egregiously wrong was the phrase that was being used by the counsel for the state of Mississippi. And so Kavanaugh kind of outlines some of it.
Yeah,
Josh,
there was
do
a
you want to
really
talk a little
interesting
about that?
exchange. Yeah, I thought this was a super interesting exchange. So Kavanaugh functionally says, the court has been forced to pick sides on the most contentious issues of debate. Some argue that since the Constitution doesn't mention abortion, that the Supreme Court should be neutral on it too. Wouldn't overruling Roe and Casey return us to a neutral position? And then Rickleman, the lawyer for the Center for what is it, Reproductive Choice? Am I getting their name right?
Jackson Women's Health Organization.
Okay.
I think. No. Yeah, she's with the Center for Reproductive Choice, but she's representing Jackson Women's Health Organization. Yes,
okay.
You're correct.
Yeah, that's right. So C basically says, well, the court rejected that argument in Casey, and it wouldn't be neutral since abortion rights is based on liberty, which is in the Constitution. States shouldn't take control of women's bodies, or else women will never have equal status. But then Kavanaugh pushes back and says some of the most controversial cases in this court's history happened when we overturned previous cases. So if we think that the prior precedents are seriously wrong, why should we not return to a position of neutrality? And I didn't think Rickleman's response was that good. He said the view that a previous decision is wrong is not enough to overturn. The state hasn't made new arguments here, so we shouldn't overturn 50 years of precedents. I thought that was a terrible response to Kavanaugh's question.
Yeah, I mean, she's relying on the Casey test here. She's saying, well, there are no new facts of the case. The reliance interest is still there, and therefore it's not the court's business to consider whether to overturn Roe and Casey. And she's trying to argue, and the counsel for the U.S. tried to argue against Alito later, unsuccessfully, which I'm so excited to talk about.
Yeah, let's talk about that. That was amazing.
That the cases where the court overturned other major precedents were actually cases that were perfectly in line with the test in Casey. And then Alito kind of lays down the hammer. And so Alito has this exchange with the counsel for the U.S. in which he presses her on Plessy v. Ferguson as one example. For those who don't know, Plessy v. Ferguson was the separate but equal case. It was the Supreme Court declared that it was an acceptable thing under the Constitution, even with the Civil War amendments, for the South to segregate facilities based on race, as long as those separate facilities were equal in some sense that I'm sure was circumvented frequently. And so that was finally overturned in the Brown v. Board of Education case, in which segregated schooling was found unconstitutional. And so Justice Alito asked the counsel, what if the year after Plessy was decided, we had another case come up to the Supreme Court in which we had the opportunity to overturn Plessy? Should we do that? And what he's doing, and he's stipulated, same facts. The information is the same as at the time Plessy was decided. And he's presenting the counsel with a dilemma. Either she has to affirm that you need new facts, or some new data. So Justice Breyer kind of tried to hand out the line that, well, we had all these new facts because we discovered that there were psychological harm to people, and so we didn't know that at the time of Plessy, which is a terrible argument. It's a terrible argument for why to keep segregation legal. And Alito basically says, did we need that data, or should we have overturned segregation at the time? Like, did we need 58 years of data on segregation? And she doesn't want to have to say, yes, we did, because she doesn't want to stand for 58 years of segregation under Plessy, but she also doesn't want to say, no, we should have overturned the egregiously wrong precedent at the earliest opportunity, because then it undercuts the stare decisis argument against or in favor of maintaining Roe or upholding Roe and Casey. And what she did was she said, well, yes, we should have overturned Plessy because the facts of the case were wrong at the time, but we've never in our history overturned a case in which there weren't facts changed, which is to say it's a non-answer. And yeah, she just...
that was one of the better moments.
It was really clear, because I think most people would agree, even lawyers before the Supreme Court would agree, that we should have overturned Plessy at the earliest possible opportunity. And there were powerful dissents. Justice Harlan, for example, wrote a powerful, if slightly conflicted dissent, in which he argued that the black-white segregation under Plessy was wrong at the time it was decided.
Let's talk about this next thing that happened. So they're talking about overturning precedent and public opinion. So Kavanaugh had a great moment, kind of listed out a bunch of examples of cases that have been overturned. And I thought at this point, Justice Sotomayor had maybe her best moment of the morning. Like, I mean, I think she didn't come across great some of the time. I've heard, I forget who it was. I think Jonah Goldberg, I think, described her as like the hackiest Supreme Court justice at this point. So I think there's some fairness that actually comes across very, very biased, very, very partisan. But I felt like this was a very interesting counter argument. I don't think it wins the day, but I thought it was interesting where she said, well, the cases that Kavanaugh listed, like Brown v. Board of Education and Plessy, are cases where, unlike if you overturn Roe and Casey, then it goes back to the people, basically, right? It goes back to the states. It becomes a state's issue, and every state is going to do what they're going to do. And you know, something like 15-ish states are ready to basically ban abortion or most abortions right now, and you got another 15 or 20 that would do the opposite, like New York, that would just like keep all abortions legal. California would, and then you've got another 20-ish states, 25 states where it'll be a big battleground, right? So that's what would happen. And Sotomayor says, okay, in cases like Brown v. Board of Education, we didn't turn it back over to the people. The Supreme Court functionally said the Supreme Court was wrong in the previous case, and we're not giving it back to the people. We are fixing it. It was wrong the day of the Dred Scott decision or whatever, and so we're overturning that. I thought that was a really interesting case. I think it doesn't mean that we shouldn't overturn Roe and Casey. Because abortion's not in the Constitution, so I think it's a different situation. But I thought that was a pretty good moment for her.
Yeah, I think it was kind of highlighting the nature of 14th Amendment jurisprudence a little bit. So the 14th Amendment is used very frequently to vindicate the rights of individuals against the state. And so the state has generally broad freedom under the 10th Amendment. Any rights not enumerated revert to the states. But the 14th Amendment enables the federal government to preserve constitutional law, constitutional rights against state regulation. So they can still tell the states what to do with the 14th Amendment as the hook. And so she's right. With 14th Amendment cases, it's things like, well, the state of Mississippi says that you can't do that, but the federal government says you have the constitutional right. And so we're going to tell the state of Mississippi, you can't abridge that individual's right. So that was the one occasion that, strictly speaking, Justice Sotomayor was not wrong, I think. It would be fair to say during oral arguments.
And this is where it was a little bit frustrating that the way that the case was set up, it wasn't like Stewart was never really arguing for fetal personhood, right? He's, he's arguing that, maybe the unborn feel pain and we've been able to see them more, like he says at one point. And it's like, that's the best you've got? Because at this point, this is where a personhood case is really helpful because, if Sotomayor says, well, we're trying to, in all these other cases, we're trying to give rights back to people. It's like, hey, we want to give rights back to the unborn, who, philosophically speaking, there's not a very good reason to think that they are special, or the opposite of special, that they're different than the rest of the human beings that have these rights. And so make a personhood argument, but instead, at this point, they're making a states' rights issue, which I think was weaker.
Yeah, it's like you've got the clear personal individual right that women have of, and again, liberty, autonomy. Is it bodily autonomy? Is it autonomy of decision? It's very unclear. But at any rate, we would say that women have clear rights to bodily autonomy. That's not really a question. And so you've got clear individual personal rights, the sort of rights that are normally vindicated under the 14th Amendment. And the state is opposing states' rights, which are the sort of thing that get thrown out under the 14th Amendment. When there's a very clear argument to be made that the individual whose right is equally at issue with the woman's right is the fetus, the unborn human being. And it's because not only is he trying to argue against Casey from within Casey's framework, he's also trying to argue within the kind of originalist, like legal positivist framework. For example, the late Justice Scalia was well known for. And it means these big moral questions are kind of thrown out to some extent. You don't discover rights, you legislate them, more is the attitude. And what did they originally put in when they were talking about the 14th Amendment? Did they originally consider fetuses to be people? And we didn't even get there, which was frustrating.
Right.
But if you want to talk about contesting the facts of the case, let's contest the fact of Roe that no one knows when life begins. That's a clear contestable fact. Biologists know when human life begins. Human life begins at conception. The question of whether the zygote which exists at conception is a rights-bearing person whose rights ought to be vindicated as a person under the 14th Amendment is a whole different question. But
philosophical question.
What Roe used to get there was wrong. It's a changed fact of the case, but we didn't even go there, even though it's the most important question.
I want to bring
that was
Emily.
The most frustrating thing.
I want to bring Emily into the discussion because Andrew and I have been talking a lot, and Emily was also watching the oral arguments live. And so, Emily, to talk a little bit about something that I've already seen mentioned in the comments. I think this might have been the thing like that the most pro-life people like winced at, which I think is a good sign because I think this was a bad moment in the arguments. But let's talk about the whole religious accusation.
Yeah, so Sotomayor at one point accused Stewart, who's the lawyer for the pro-life side, that his view is purely religious about when human life begins. And that brings it back to the whole thing that we were just talking about with the idea of the pro-life side really trying to make a states' rights argument instead of trying to make a personhood argument. They really dodged the personhood question entirely, which, in my opinion, wasn't the best move because this is precisely what happened. Sotomayor accused him of having an only religious argument. He did come back saying that it is a human organism, and then went on to say that people should be able to debate the philosophy and decide that locally himself, rather than making some sort of personhood argument of saying, we know it's biologically human, and I'm now going to argue that it should be a person with rights under the 14th Amendment, and that by us, overturning that precedent, we are actually returning returning rights to someone that should have had them all along. We're fitting that thing that Sotomayor pointed out, that the only time we get to overturn something is when we're returning rights. And so he could have made that argument, but he didn't. He said that it's something that should just be done locally. We should be able to have these kind of debates amongst ourselves. And so it was a huge missed opportunity for that personhood argument. And then he was asked, are there any secular philosophers who think that personhood begins at conception? And this is when we all, like the three of us, were sitting on a Zoom call watching or listening to the live oral arguments together, and we all freaked out because he was asked the question, are there secular philosophers that believe that personhood begins at conception? And Stewart said yes and couldn't name a single one. And it was incredibly frustrating on multiple levels because, number one, he should have been able to name someone. I mean, come on. There's lots of secular arguments for why personhood begins at conception. We use them at ERI, and one of the biggest ones is the equal rights argument. You can find it on our blog. I think Tim's going to throw a link in the comments for you all. We have an amazing article arguing from equality, the personhood of human embryos, using completely secular arguments for personhood. They are out there, and quite honestly, he should have known that and been prepared with something. But it also begs the question, what does it actually mean to be a secular philosopher? Because when he was asked that question, like, are you allowed to be a secular humanist? Like, do you have to be actually, say, an atheist? Are you allowed to be Christian but making secular arguments? But even secular humanism itself is considered a religion under the
Supreme Court dicta.
I don't know what's going on. So it was extremely frustrating on a lot of different levels. One other really great point that our friend Ali Rack brought up was that he could have also named several pro-choice philosophers who concede that abortion is taking of a human life. We know of several of those. The strongest pro-choice arguments out there are people that say, yes, we recognize this is a human life, but you should be able to terminate that human life because of bodily autonomy reasons, or up until after birth because it's something really sophisticated. That, like, there's really smart pro-choice people that admit that life begins at conception, and he should have been prepared with that information and wasn't. So it was just a really frustrating moment, I think, for all of us, and a lot of people in the chat have been agreeing with that.
Yeah. Super frustrating. It did happen the other way as well, though. So I believe it was the counsel for Jackson who was asked, what is the principled reason, the principled non-religious argument for why viability is a good line? And the principle was basically, well, it's the clearest line. And it's been working.
Like, what? It's not the clearest line.
It's not clear at all.
It's a moving target, y'all. Go ahead.
I think the thing that made the whole, the pro-choice lawyers and the pro-life lawyers making these personhood arguments, that made the whole thing the weirdest to me, I guess, was that the Jackson women's health lawyer and the U.S. lawyer both admitted in some sense that the fetus has some level of interests. Their whole claim about why viability was good is that it's this balancing point where we're able to balance the interests of the woman and the interest in protecting life that the state has in protecting this life, essentially. So they kind of granted the fetus some interests, but Stewart, who's the pro-life lawyer, wasn't willing to kind of jump on that and actually make a personhood claim that, yes, the fetus has interests and we should be protecting those interests, etc. Like, the pro-choice people in some way actually did admit that there were fetal interests there, but instead the pro-life side decided to make a states' rights claim instead of really jumping on that. And so it was this kind of weird reversal where the pro-life people weren't willing to make a personhood argument and the pro-choice people somewhat conceded at least some level of personhood, that there are some level of interests there.
Yeah, I wouldn't say they conceded personhood, just to clarify, but that the state can have any interest at all, which, by the way, is a departure from Roe, I believe. That under Casey, it's allowed that from conception there is some like tiny little bit of interest the state can have, and that interest grows over time, and then at this magical point, the equilibrium tips, and sorry, Josh, I interrupted you.
Just to clarify, no, you're right. So just to clarify that's in Roe too. The idea is, like, every trimester the state can have more interest in this potential fetal life. But I want to point out an interesting comment from Jack Richmond, and let us discuss it just briefly. Because he says there's no way a personhood argument, which would necessitate a 50-state ban, would have played with 5 of the justices. Not making a personhood argument and appealing to neutrality was probably key to getting Kavanaugh, the median justice, on board. That's an interesting thought to me. And my instinctive response, and I want to hear from Andrew and or Emily, my instinctive response is, okay, that might be true. So it might be that they're doing this for a legal strategy, and that might be the right move. But unfortunately, by doing that, you then end up making these kind of goofy, not optimal arguments. Like there's clearly better philosophical arguments that can be made, and you're dodging questions, I guess, basically just to try to make the legal strategy thing work.
Yeah, I think Hadley Arcus wrote earlier today that he was arguing with one hand tied behind his back, essentially. And the idea was the strategy of the case is to hang it on this originalist, textualist, what did they mean when they wrote it? Let's look at every word thing, which is why he kept repeating text and tradition and that kind of thing, instead of making a principled argument. So I think when I say personhood argument, I should probably be a little careful. So I've been talking about personhood under the 14th Amendment, which, yes, I think the personhood argument as made by, for example, John Finnis, who was a professor of Gorsuch, which may or may not be relevant. He argues that the 14th Amendment, fetuses are people, and therefore their right to life under the 14th Amendment should result in a nationwide abortion ban. Basically, the anti-Roe. Instead of just overturning Roe, it would be Roe the opposite direction. I believe that would be the morally proper call. That would be the legally proper call. Whether or not the justices have the stomach to do that is a separate question. But at the same time, there's arguing that maybe this viability balance is wrong because we know more about the fetus and we know certain things that, like, clearly this should affect the calculus. We don't have good reasons to believe what was said about the value of the fetus in Roe to be true. And I think even the extent to which you shift that line, that undercuts Casey in a better way than suggesting that, well, maybe viability itself doesn't work and you can use undue burden unclearly somewhere, and you probably shouldn't, because you should just overturn Roe and Casey, which is my summary of the argument that the counsel for the state made.
Yeah, he functionally did. Do you have any thoughts about that, Emily?
I think it'd just be helpful to clarify for our listeners. It sounds like what I heard you and Andrew kind of say was that maybe it was the best move, and this is kind of taking it back to exactly what that comment said and kind of directly answering it, but maybe it was the best move to focus it as a states' rights thing as opposed to making a personhood argument coming in. Maybe that was the best strategy move coming in. However, when they were point blank asked the question about personhood, it felt like they were now had their hand tied behind their back. Like they weren't able to bring out that personhood piece because they'd kind of forced themselves to not be able to. And so I think that's ultimately why we're questioning their decision to focus it solely on states' rights, because once they actually got into it and they were starting to be asked those questions, we have answers, and it felt like they were trapped and couldn't use them or didn't want to use them, or I'm sure they know them, but they just like weren't able to bring them out because of the way that they framed the case. Is that a pretty accurate kind of summary of our reaction to that comment and what we thought their strategy was?
Yeah, like, I mean, I would consider myself open-minded on it and, open to people who understand, Supreme Court legal strategy better than I do, to kind of explore, even for Arcus to say, no, here's exactly why we shouldn't do that. I'm open to that argument. I think we're kind of reacting to what we heard of the oral arguments as, people who love philosophy and seeing, these should be some of the best thinkers of the land, men and women before the Supreme Court making the most interesting art. Like when I think of like The West Wing is one of my favorite shows, and I know it skews super left, but I still love it. It's super optimistic. I need to do more apologist reacts to it just so I can watch it again. But like, there's this wonderful episode, and it's like, this would never happen, but there's a wonderful episode where they need to nominate 2 Supreme Court justices, and they end up, and then one of them is going to be the Chief Justice, I think. And it's like, and they end up ultimately bringing on like functionally a liberal and a conservative, because it's like, there are these 2 brilliant minds. And when they talk to each other and they're quoting all these cases, it's just like these really great things happen, and they can instantly go to the depths of an issue and all of that. It's like the super like optimistic thing. That is what's to be happening. Instead, we're seeing every single one of these lawyers, including the pro-life guy, making sometimes decent arguments, but sometimes making pretty crappy arguments. And it's just like, why? That's frustrating.
Right, so this reminds me of something I kind of missed earlier that I definitely need to go back and outline. Is in law, you can make multiple arguments. You can make multiple mutually contradictory arguments. As long as one of them sticks, you win. And so the state could say, so first of all, the state does this already. They say, you should overturn Roe and Casey for these reasons. If you don't accept these reasons, you should at least overturn the viability standard for these reasons. And so why not add a third level at the top that is, you should overturn Roe because fetuses are people under the 14th Amendment. We have originalist analysis. We have natural law analysis. We have, throw the kitchen sink. Because why not have another argument? Because you don't have to win on that argument. You can push the window in your direction with that argument and win on the second argument, and that's still winning. You can, I think the idea that even if the state doesn't prevail, even if there's some sort of middle path decision, and Roe and Casey remain technically intact, the state is still winning its case in upholding its law, even though they lost on their larger case to overturn Roe and Casey.
Yeah.
I just want to highlight what you just said, Andrew.
Yeah.
Because it was something that I didn't understand when we were watching the oral arguments. And when we were debriefing about it afterwards, this is something Andrew had to explain to me. So I feel like there's probably a lot of other people that were in the same boat as I was. The idea that you should make as many different arguments as possible, and they can contradict each other. And it doesn't really matter if one of the arguments doesn't work, the next argument might work, or the next argument might work. And so the best legal strategy would be to have as many arguments as possible. And the reason I got confused about this is because that is precisely not what the pro-choice lawyers did. There were effectively 2 pro-choice lawyers, okay? Because we had the one from Jackson Women's Health, and then we had the one who is like representing the US. And so we've got these 2 pro-choice lawyers, and when the second one got up and did its little spiel, it was all the same talking points that the first pro-choice lawyer had used. And my brain said, oh, well, that's so smart. Of course, they should be working together and comparing notes, making sure that they are pushing home the same things, they answer the questions in the same way. You want to make sure you have consistency, right? And Andrew very quickly corrected for me that I was totally off base. That's actually not what the best strategy is. They should have been trying, if I was advising the pro-choice people what they should have been doing, it is smarter for them to have lawyer A make 5 different arguments, and then lawyer B make 5 completely different arguments, because only one of them has to work. And so similarly, we are suggesting that it may have been smarter for the pro-life lawyer to have made as many different arguments as possible, and personhood can be one of those. It doesn't have to be the main one, but there's a lot of different places he could go. You don't have to just stick with one argument as your main strategy, which is something I did not realize would be important in this kind of a case.
I think Jack Richmond's follow-up comment also is plausible. He said making the person argument in an amicus brief was probably helpful, as it effectively makes overturning Roe the moderate position. That's a pretty interesting thought. Yeah. Andrew, what were you going to say? And then I'm going to move us on.
So I hope I'm moving us to the same place as you.
Basically,
the idea of using a lot of different arguments kind of plays out in the way they talk about liberty, in which liberty just becomes the holder for all of the possible justifications.
All of the above answer is what it was. It was the all of the above answer. Yeah.
It was not only the all of the above answer, it's the liberty is actually in the text. Privacy isn't. Autonomy isn't.
Right.
Liberty is.
It's an interesting legal move. It's not one that I was predicting. Like there is a thing that happened that, like functionally, so Ruth Bader Ginsburg had multiple interesting thoughts about Roe. One was that Roe was poorly decided. They shouldn't have decided the way they did. And she's made some really interesting comments about that functionally that the Supreme Court botched Roe, and the reason we're still talking about abortion, the reason this is still such a contentious issue decades later, is because of how the Supreme Court handled Roe. But she had also said, like, it shouldn't be the right to abortion, which she firmly believed in, shouldn't be based in the right to privacy. It should be based in equality. And so I felt like I heard from both of the pro-choice counselors them making arguments that were closer to what Ginsburg would have wanted in the beginning. That, like, for women to truly have equality in society, they need abortion, which is certainly better than, I think, a privacy argument. But they were using liberty a lot of times as, shorthand for that sometimes. But definitely, we heard bodily autonomy talked about a lot yesterday. And we've been saying it here from the very beginning. Pro-lifers need to understand bodily autonomy arguments. You need to understand the different kinds of bodily autonomy arguments and how to respond to them, how to refute them, because I actually think most pro-choice people, like, this is more fundamental to their pro-choice beliefs than believing that the unborn is not a person. And pro-lifers are more used to talking about the unborn having value, and that is important. We want to talk about that. We've got the equal rights argument. Go watch the video, go read the article. But you better be ready on bodily rights arguments, because a lot of pro-choice people are not going to change their mind unless you respond to their pro-choice argument. Tim, see if you can find, I didn't put this in the notes, but see if you can find this link. I recently did an interview with Stand to Reason on their podcast. And functionally, that interview, it's like an hour long, is me going through some of our most important bodily autonomy material. Like, there's a really, really fun time with Tim Barnett at Stand to Reason, who basically, like, at Stand to Reason, they've been responding to bodily autonomy for decades, like certainly longer than your eyes been around. But he had watched the speech that I had done. It was like, I really learned some stuff with this speech. Like, I really want, and he just loves that we're kind of doing R&D in campuses, and just felt like there's a clarity to the way that we talk about it. And so if you want kind of a crash course on bodily autonomy arguments, listen to that interview with Stand to Reason. I think that worked, that went really well. Let's talk about the safe haven laws thing that Justice Barrett was bringing up. I thought it was so Justice Barrett basically says, here's is presumably something new that has happened since Casey, is functionally every state has a safe haven law where, a relatively new mom, in some states it's not even a new mom, but it's like the age can change based on the state. But functionally every state has it, that you can take your baby that you cannot care for and take it to usually a hospital, sometimes even a fire station, but you need to, hand it over to, a medically trained professional, and, maybe sign some quick paperwork or whatever. But functionally, you can just a very quick, this is not my baby anymore. I'm handing it over to be adopted. And we basically we didn't want to see so many babies being left in dumpsters and stuff like that. So like after that passed the first state, it passed the other 49 within like a couple of years. It was just like so obvious to everyone. Like, of course we should have safe haven laws. And so she said, like, isn't that a new thing? And doesn't that help, respond to your liberty argument that women need abortion for equal status in society? They have safe haven laws. And both, the counselor representing Jackson as well as the US DOJ had the exact same two responses to the safe haven argument. I thought one of them was a good argument and one of them was a terrible argument. The good argument, I don't think, again, persuasive, but decent, was this idea that, well, that doesn't solve the bodily autonomy issue, which is true. Like, safe haven laws, like, if we make abortion illegal in some state, then a woman still has to go through the full pregnancy before she can do the safe haven law thing. You can't do we cannot Star Trek beam the baby, to the fire station or the hospital from her womb. So she still has to go through that 9 months. She still has to go through the delivery. I think that is a decent response. Her bad argument that I don't know why they added this because this is so much worse, was to say that adoption was already a thing in 1973. It's like, yeah, but it was really different. Adoption was a super different thing, and it was a lot harder in 1973. Go ahead, Andrew.
Well, I think I have an idea as to why they added it. It's because
why?
Roe and Casey talk a lot more about the challenges of motherhood than they do about the burdens of pregnancy.
Okay.
Which just goes to show how much arguments have changed since then. The fact that ERI is saying bodily autonomy arguments are the main thing pro-choice people are using does appear to be true. I mean, that has completely changed since then. And so really the focus wasn't on the burdens that are going to happen afterwards, which you could get rid of by using the safe haven law and giving the baby away at a fire station or a hospital. It's about the focus of burdens during pregnancy and during childbirth, and that you just can't get rid of. And that's really where the new pro-choice focus is. And that's the part that pro-life people need to understand, is those kinds of bodily autonomy arguments, what's happening to you during pregnancy.
Yeah. And I think one of the councils, I believe it was the council for the U.S., said, well, it's just the same as adoption, and adoption is like too much of a choice, like to have to expect people to make. And I was floored by this, because abortion is a huge choice to have to expect people to make. Like, if you're going to expect women to have to make a difficult decision, I don't understand why adoption is so much categorically more difficult than abortion. It was just a really lacking feature of the argument, and I think it's because they were trying to make the motherhood is difficult kind of argument before, and Justice Barrett was really targeting that.
Yeah, he was really undermining that. Contraception got talked about as well. And interestingly enough, the pro-choice counselors from Jackson and US DOJ admitted that contraception won't eliminate abortion. I appreciated that, because weirdly, so many pro-choice people seem to think that just more contraception, like we will have no more abortions. Like, I hear this on college campuses all the time, and it's just like, look, I am more than most pro-life people willing to concede that probably one of the multiple reasons that the abortion rate has been declining for decades now is it more readily access to contraception and more people using contraception well. That is probably one of multiple reasons that the abortion rate is going down. And I'm willing to concede that. I don't think I'm like conceding a bunch of pro-life ground here by conceding that. That's probably the case. But so many people are like, okay, but if you make contraception even more available, then suddenly it's going to like completely go away, which is like, I think this at that point an overstatement. You've got Alan Guttmacher Institute research saying that 54% of women having abortions were using birth control the month they got pregnant. So it's like, hey, it's not going to completely. You might decrease it some, but it's not going to make abortion, like even rare. And I thought Stewart, who, I dog on a lot for some of the weak arguments he made, but I thought he did have a good rebuttal to this point when he said that, look, contraception is more available and affordable now than it was in Casey, which is true. And he said, look, the lowest cost of an abortion, the cheapest abortion you can get at Jackson Health is $650, not to mention the travel costs on top of that. Contraception costs are a lot less than that. So yes, okay. Maybe there's some people that don't get contraception for free, although under Obamacare, like a lot of people can get contraception for free at this point, depending on where you work. But look, even if you're not one of those people, it's less expensive than $650. Emily, talk about, there's a really extreme phrase that was used yesterday that I know we talked about as a staff. I think everyone's eyes went wide when this was said. And I want you to talk about a bit about both the idea of forcing women to stay pregnant, but also that banning abortion would be a state seizure of a woman's body.
That phrase, absolutely, my eyes popped out of my head. That banning abortion is a state seizure of a woman's body. I mean, it all goes back to the idea of really what is banning abortion, and it is controlling women's bodies as far as the pro-choice lobby is generally concerned, that we're forcing women to continue going through pregnancy, which is really just kind of a variation of the standard bodily autonomy argument, the idea that a woman has a right to do what she wants with her body. And so if you are regulating that in any way, you're essentially forcing her to go through this pregnancy, which would be basically taking away her liberty, to use that word that they threw in there 5 million times. We have several resources at ERI that can help you kind of respond to that claim. I'll point out two really quickly. Our main blog article on this topic, it's called Pro-Lifers Are Not Forcing Women to Stay Pregnant. I think the link's going to go in the chat. We also have a YouTube video on that. We recently did this quick response series, and it's still ongoing. I bet a lot of you have watched a good portion of those videos. But quick response number 7 is specifically on this topic, that banning abortion forces women to stay pregnant. It's a really short video responding to it, but I'll summarize the main points here. Basically, we are not convinced, and they did not make a convincing argument for this by the lawyers. The lawyers just kind of threw out that phrase that we're forcing women to stay pregnant and didn't actually prove why that was the case. We're not convinced that arguing we should take away one option, essentially arguing we should take away the option of abortion, is equivalent to forcing someone to do something. So a quick thought experiment that you'll see us use in our video. If, let's say that I was being held at gunpoint, crazy thought experiment, here we go. I was being held at gunpoint and told by this gunman that I had to choose either chocolate or vanilla ice cream out of this soft serve machine. Like, there's a soft serve machine here. There's only 2 handles, chocolate and vanilla, so I have to get ice cream. All right. He is trying to force me to do that. But then Andrew comes over and he takes off one of the ice cream handles. He takes off the chocolate side. It would be absolutely absurd for me to get upset at Andrew and say, Andrew, you are forcing me to choose vanilla ice cream. Because really, it's the man at gunpoint who's forced me into this decision, right? Andrew just took away one option, but that is not the same thing as forcing me to choose vanilla ice cream. Similarly, if we looked at a situation with a toddler, a classic case that pro-lifers use a lot, if we make this into a chart of a toddler and look at the idea that if there was a woman who was in a really, really difficult circumstance and she wasn't going to be able to or didn't want to continue caring for her toddler, and someone says, well, you don't have the right to kill the toddler. You can't do that. That isn't the same as forcing her to continue to be a parent. Even if all of the other options were off the table, even if we, called Child Protective Services and said, we really need you to take this child off our hands. And they said, we're so sorry. There's World War III going on and we just need you to hang on for 9 months because we are absolutely booked solid right now, but we will be able to come take that child for you. We just need you to hold on 9 months. That is not the same thing as forcing her to continue to be a parent. That's simply saying you can't kill the child in the meantime. And so they didn't really make a compelling argument for why forcing is the word that we should be using, why we are actually forcing women to stay pregnant, because it's really not philosophically the same when you think through other types of situations, that taking away one option, essentially saying that abortion is an illegitimate option. It shouldn't be an option on the table. Killing should never be an option on the table. It's saying that not being an option shouldn't be the same as saying we're forcing someone to be pregnant, essentially. So if you want more on those resources, those are kind of the 2 main places, the blog and the YouTube video. But that was a theme that was brought up a lot in the bodily autonomy kind of section of the arguments, of the idea that pro-life people are forcing women to do something. And that's just not really philosophically what's actually going on.
Yeah.
Yeah, and then there's this other aspect where the line that the counsel for Jackson and the counsel for the U.S. both want to draw is viability. So why is it that states get to force women to be pregnant for the last 16 weeks? Like, if forced pregnancy is a problem, why is it only a problem for the first 24 weeks? Why is it suddenly not a problem after viability?
Yeah.
I mean, I think basically what that points to is the main issue with kind of bodily autonomy arguments in general, is that people tend to want to restrict abortion at some point. We know that 72% of self-identified pro-choice people, in a recent study, it was an NPR study, we have it linked to in one of that quick response videos that I was talking about, 72% of pro-choice people believe that there should be restrictions on abortion. But that position isn't congruent with the idea that you like have to be having full bodily autonomy. And so if we're restricting abortion at a certain point, whether that's viability or whether it's later on during the actual pregnancy, like no matter where we put that line, we're still forcing women to be pregnant for some certain point after we put that restriction in place. And so there's no way to have a consistent view that says both we have to be letting women do whatever they want with their bodies, we can't force women to be pregnant, but also we should be restricting abortion at some point. It's a obvious problem, and Justice Thomas actually kind of brought this up to an extent.
Yes, he did.
I'll toss it back to you, Andrew.
So, if you're familiar with our materials, we use an argument using the example of thalidomide. It's a pill that used to be prescribed for morning sickness and was found to cause serious birth defects. And so the question we ask is, working through bodily autonomy arguments, does a woman have the right to relieve her morning sickness using thalidomide? Let's say it's lawfully prescribed, knowing that it's going to cause harm to the fetus. And usually that's a point at which people have a hesitation. Well, Justice Thomas actually brought up legal precedent of this kind of situation. He basically makes the thalidomide one argument. There was a case in which, after Roe, a mother was prosecuted for child neglect because the child was born with, I believe it was cocaine in the system. And so he was pushing why, this was after viability. Could she have used cocaine before viability? Would that have been within her rights? And if not, why is it acceptable to kill the fetus, kill the human before viability, but not acceptable to harm the human before viability?
Yeah, there was this, I thought that, so I actually wrote down a little part of this exchange. So Thomas says, so he brings up that case and he says, what if she had done that pre-viability? Like, should she still get charged? And Rickleman responded that states can regulate that pre and post viability, but this case is about abortion. So it just kind of like ignores the thought experiment, doesn't respond to it. But there was an ironic admission when this came up with the US DOJ counselor, when he said that we're not denying that the state has an interest in protecting children from being harmed in the womb, but that shouldn't outweigh a woman's ability to have an abortion at any time. And I'm just like, we think that children are harmed in the womb in every abortion. Like, what are you like?
That is why we are against abortion. That's it right there.
Mm-hmm.
They said it.
Mm-hmm. Yeah. Well done. There was an interesting line made, like a fact asserted that I was like, wait, what? Where the claim was that carrying to term is 75 times more dangerous in Mississippi than a pre-viability abortion. Now, Andrew, correct me if I'm wrong, but we weren't able to end up fact-checking that one, right?
Not within 24 hours, no.
Yeah, because fact-checking these things is really hard. We have a piece on this that Tim will post in the chat. Is one of our, I think, our kind of cornerstone pieces. It was the most popular piece on the blog for 1 or 2 years. Which is the idea, is abortion 14 times safer than childbirth? Because you hear it, because that's usually the statistic quoted, like at the national level. And one of our volunteers basically just did an amazing job showing that this is based on one study with the worst flawed way that it was put together ever. Like, no one should quote that again. But he really had to dig into the weeds to be like, hey, where did this all come from? And so it's like, where are they getting the 75 times stat? Like, basically, I don't buy it, but it's impossible to fact check if you don't know where what that source is. But I am very skeptical.
What's interesting too is Justice Sotomayor was the one who cited both. She also cited the abortion is 14 times safer than childbirth earlier on in oral arguments.
Yeah,
she made a number of those kind of arguments that we see
so
circulate.
Check out that article if you've not checked out that article, that is one to bookmark and have ready to know it so you can respond to people who make that claim to you, but also kind of have it ready if you're in a like a social media debate or something like that. Okay, where else do we want to go? Do we want to talk about the legitimacy stuff, guys?
Yeah, let's do it.
Yeah.
All right. So Andrew, why don't you start?
Okay. So, if you were listening to the oral arguments, you may have noticed that the first couple of questions by the liberal justices or the pro-choice justices on the court seemed to be more like speeches than questions. And those speeches were addressed to one person. That person is Chief Justice John Roberts. Roberts is maybe most known for being kind of an institutionalist, which is to say, he wants to preserve the legitimacy of the court as an institution. He wants it to be perceived as above the fray, as a neutral, reliable arbiter. And so he makes sometimes very questionable decisions in order to preserve that. One notable example, he, I believe, wrote a lot of the what ended up being the minority opinion in the Sebelius case on Obamacare before flipping over to uphold Obamacare. And concerns about the legitimacy of the courts, the court staying above the political fray, were part of that. Also, interestingly, in the duology of the Hellerstedt case and June Medical Services on a much smaller abortion regulation than is at issue here, he voted against the abortion regulation, or to uphold the abortion regulation, in the minority in the first case. In the second case, he voted to strike down the abortion regulation because it was a precedent because of the previous case. And so he is a very frustrating person at some level because he's got this kind of pragmatism. And so the other justices are appealing to that and saying, look, if we overturn this, that's 50 years of precedent that we are throwing away. There is going to be chaos. There will be issues. There are going to be new cases, even if you try to find a middle ground. If you throw away this right, it's going to make us look like we're just a political body. And by the way, we have 3 new members, and they were all appointed by Trump. And that was legitimately an argument that Justice Sotomayor made, which veered towards disenfranchising those 3 justices, by the way. That, if they vote a certain way and Roe is stricken down, then it's a political decision automatically. But if they vote the right way, or we get the right decision, then it's an acceptable decision that upholds the legitimacy of the court. And so they're arguing, and again, Justice Sotomayor used the word stench, that if they overturned Roe, that it would leave a stench about the court. The pro-life view is a stench, apparently. And so there's this idea that the court has to be above the fray, that is an important enough thing, essentially, that if they undercut their own legitimacy, then future decisions would be hampered, even if it would call into question, whether they made the right decision in this case. So even if one could say Roe was wrongly decided, even if they should overturn Roe on the merits, maybe it would undercut the legitimacy of the court to overturn Roe, and therefore we should leave it alone because it's a super precedent and because it's a politically contested issue. So, yeah, that's legitimacy in a nutshell.
Tim Hold, jump in. You had a question for the panel, didn't you?
I did. I think we have to kind of rewind just a little bit. So my question comes to that viability issue. So do you guys know of any cases where somebody has sought an abortion that was past the viability line, where they just induced labor and delivered the child and kept them in the NICU until they were able to go home or to be adopted by somebody else? Has that ever happened? Or is the viability line just kind of like this random, like it's possible, so therefore you can't perform an abortion because they're potentially viable outside the womb? Please clarify that for me.
I'm not aware of a case where a woman says she wants a late-term abortion. Like clearly this would be, well, actually I shouldn't say clearly. I mean, it could be an elective or inelective thing because the C-section is faster than a late-term abortion by a wide margin. A C-section is like, you can get in there in 20 minutes. One of my kids was born through an emergency C-section. It was so fast. Like we skipped way in front of the line. We were supposed to be there like most of the day. There are a lot of people before us, and then they're watching the fetal heart monitor, and suddenly everyone moved really fast, and my wife jumped to the very front of the line. The kid is fine, Eli is fine, but they were probably in there in 20 minutes. So versus a late term abortion, which is a multi-day procedure. So I'm not personally aware of a case where a woman wants an abortion or is planning on having an abortion and is convinced to instead induce labor early and have her baby in a NICU and then adopt it out. That doesn't mean it hasn't happened, but I don't know that story.
Yeah, the only thing I can think of, I think Charles Camozzi in Beyond the Abortion Wars mentions the idea of that kind of situation as relating to basically hospice care for fetuses with severe anomalies. And that's the only case I'm aware of. But one of the interesting things is if the state theoretically has this interest in the health of the fetus, it's reasonable that the state could legislate, or that it could be within the realm of medical ethics, not to allow someone to schedule an early delivery at that stage, because it would harm the chances of survival for the fetus. That pushing it out another 2 weeks drastically increases the odds of survival, and therefore the standard of care, now that we're counting it as a patient, would be to increase the odds of survival. So that complicates that somewhat.
Yeah.
Thanks.
Emily, let's jump back and talk about the whole viability versus 15 weeks thing that was being discussed and the European laws. Because I had you do some fact checking today about the European laws, and I was very interested. I mean, not only how quickly and well you did that task, you did a really good job. So I want you to just kind of set that up and then tell us what you learned today.
Yeah, so basically, as we talked about, there's kind of a couple different ways that the Supreme Court case could ultimately go down, because the pro-life lawyers eventually kind of started making an argument to overturn Roe and Casey entirely, but there's also that kind of middle ground option that was being discussed of what if we just got rid of the viability marker and moved it to 15 weeks, which is essentially what the Mississippi law was doing, right? It was saying that we're going to ban abortions after 15 weeks as opposed to after viability. Of course, there are being exceptions. So the question that came up a lot was, is 15 weeks a better line than viability? And as a lot of pro-life people have been pointing out, and have been pointing out for years, that earlier line of 15 weeks seems way more in line with what the rest of the world, or the good countries in the world, are doing. So a lot of people have pointed out the fact that the US is on this very short and not very good list of countries who allow abortion as late as we do, like North Korea, Russia, China, like not a list you really want to be on. And a lot of people have pointed that out, as well as the fact that European countries, all these European countries, have these earlier bans on abortion, and we should be more like them. It seems weird that we aren't following the European kind of model of having these bans earlier. So 15 weeks really isn't unreasonable, is the argument. Like it's just consistent with what a lot of the rest of the world is doing. And so when presented with that, the pro-choice lawyer responded by saying that those European abortion bans, those that are happening earlier, those are really just nominal bans. They're bans in name only. They're not actually in practice. In practice, you can get an abortion way later than that. And so our point that pro-life people have been bringing up for a long time, that the US laws are so much more liberal than these European laws that are really restrictive, isn't true, because the European laws really aren't as restrictive as pro-life people have been saying that they are. And she specifically mentioned England and Canada. But she said that. She said England and Canada have basically the same laws that we do. So she was just generally making a statement about all the European countries and then specifically name-dropped England and Canada. And so my job today was to go look up and try to fact-check that information. And not super shockingly, The truth is more complicated than both she made it and the pro-life people that I've heard make that statement for years have made it. It seems to be somewhere in the middle. So here is what I basically found. I was able to find data on 27 different European countries plus Canada, because she mentioned Canada. So I included that in there. So 27 countries plus Canada. 22 of them have 10 to 14 week bans. Couple countries don't. Sweden has 18 weeks. Cyprus has 28 weeks. The UK, which is I'm assuming is what she was referring to by England, the UK has 24 weeks. Canada has no restrictions, but in practice it's 24, so that's complicated. And then there's 2 countries where it's completely illegal. So the main ones we're talking about here is the 22 out of 27 plus Canada that have 10 to 14 week abortion bans. So when Rickelman's the lawyer for the pro-choice side, so when Rickelman mentioned that the UK and Canada specifically have laws that are much more in line with the US, she was correct about that, because Canada has those no restrictions, but in practice it's basically 24, and the UK has 24 weeks. However, when she referenced the idea that Europe has these kind of nominal bans as a whole, I think she's partially right. So of those 22 countries that have those 10 to 14 week abortion bans, I would consider 12 out of those 22 nominal bans, meaning it seems incredibly easy to get an abortion after that. I found a ridiculous amount of exceptions, or ability to just get a few people on a committee of doctors to just sign off and say, yep, this person needs it for not a health of the mother reason. So when I was looking at that, I wasn't looking at there being exceptions for health of the mother or fetal abnormality. I'm talking about exceptions for basically any reason. You could get it after 10 to 14 weeks for any reason, sometimes up to 24 weeks. A lot of those countries, about half of those 12 countries, had the final cutoff at 24 weeks. Like, you can get it for really any reason, totally legal up to 10 to 14 weeks. But then in reality, you can get it all the way up to 24, but really no after 24. And then about half of those countries actually had that extended all the way until birth, where it's technically there's a nominal ban at 10 to 14 weeks, but you do have it available to you if you need it. You can get it pretty easily after that point all the way up until birth. And so kind of the summary there is the reality is it seems to me that there are 22 European countries that have that 10 to 14 week abortion ban. That seems to be what pro-life people are usually referencing when they bring up the idea that European abortion laws are much more conservative than in the United States. That seems to be about 22 countries, but in reality, I think about half of those, about 12 of those countries, Rickelman was correct in saying that the ban is really more nominal, just kind of like exceptions are allowed in the US.
So all that to say, yet again, pro-lifers, be careful where you're getting your facts from and who you're quoting, because sometimes pro-lifers also get facts wrong too. And when you do the research, you find out that it's not as simple as the sound bites say. But we try to be very careful about that at ERI. Still talking about viability. So I think my favorite exchange in the entire oral arguments was when Chief Justice Roberts asked the counselor for the U.S. Department of Justice, said, what does viability have to do with choice? And the lawyer basically says, well, it balances when a fetus can survive. And Roberts says, that's the definition of viability, not an argument. You're just saying what viability is. It's like, oh, that's so good. And then Alito has this great back and forth where he says, suppose we were considering the viability line for the first time. How would you respond to people who say that the line doesn't make sense, that is arbitrary? And as soon as this happened, I was excited because I've written an article exactly on this. Tim is going to drop it in the comments. I argue that viability is the least plausible definition of personhood. I've got a story from a campus, kind of a fun campus dialogue story in there. But it's just like, of all the places to draw the line, you've picked the one moving target. And that seems very metaphysically weird to say that, a baby at, 26 weeks, was a person in the 70s, but actually now personhood begins earlier because our medical technology has gotten better. What does that mean? That a woman gets on a transatlantic flight and flies to a country with less technology? Like at some point, her baby is not a person anymore because he goes somewhere where suddenly the kid's not viable. This. Some people actually say that's when you're a person, when your value begins. And that's just a very weird thing to say. So I appreciated Alito for asking, how would you respond to people who say that line doesn't make sense, that it's arbitrary? Doesn't the woman have the same interest in ending a pregnancy after viability? Which was a great follow-up. So Rickelman responds, yes, but viability is a principled line because, as Andrew quoted earlier, it balances these two interests. Like, you've got the women's interest, but like we're conceding there is some interest for either human life or potential human life. And so there's this balancing thing happening. So Alito responds, what is the secular philosophical argument for viability being a good line, as opposed to a point when a fetus has a certain property? And Rickelman says the court had to pick a line between conception and birth. Viability is objective, so then the court doesn't have to deal with philosophical issues. And guys, here's the thing. That statement that viability is the point where the woman and this child's interests are balanced is a philosophical claim. That's philosophy. It's a terrible argument, but that's a philosophical assertion. But she's saying that's the reason, like that's how the court can stay out of philosophy. And I think just because like you can't stay out of philosophy on this one. At some point, philosophy is part of this. It's not just science. It's not merely when does biological life begin. And it's not just legal stuff. Like philosophy is just a part of this debate.
Now, I will say in defense of the lawyer here, that because, as we talked about earlier, so frustrated, they just ignored personhood. Personhood is thrown out. So they're not talking about personhood starting at viability, which is, it's more defensible. It's no better. It's no more clear. But yeah, you've got this thing where, well, the state interests only start when, in theory, the state could like remove a living child from the hospital. And so, yeah, the state's interests can happen earlier because that happens earlier. And it's still not a good argument, but it's at least not the personhood variation that we run into.
Yeah. There is a commenter, I don't remember who it was. Tim might find it in the highlight on the screen, but it's like, I basically agree with this. It's like, this case shows that there's really only two lines that make sense, which is conception and birth. Those are the only non-arbitrary points where you can draw the line. And it seems like, okay, there are cases. This argument was made on Tangle today. Like, I was sad to see, my friend Isaac Saul made a very pretty strong approach. I mean, a strong, not in the sense of, I think, persuasive, but a fairly firm pro-choice statement today. And I think, he makes a fair point in that sometimes you just have to draw a line. So, like, why can you drive at 16 and not 18? Why can you vote at 18 and not 21? Why can you drink at 20? Like it's like sometimes you're just gonna have to draw an arbitrary line. But like, can't we agree? And I've made this point to persuade people before. It's like, can't we agree that this is a line that should not be arbitrary? That we should like be really careful where we draw it, because this is a potentially like life or death decision here. Like, where we draw that line is really significant. Can't we agree, like, well, we shouldn't just throw up our hands and say, well, we got to draw a line somewhere, so let's draw it at 12 weeks or 20 weeks or 30 weeks. Or like, well, just pick a line. And viability is a moving one. It's just like, it's conception or birth. There's the only two times when something significant changes.
And here is the bold quote from Casey. In that decision, they say, and I quote, "Liberty must not be extinguished for want of a law is clear." And they're trying to argue something like we're making the fallacy of the beard, that we're saying, well, where does it go from one to the other? Similar to Thompson's acorn argument. And it doesn't work any better on the court than it does for Thompson. It definitely not her stronger arguments in her paper. And so there's this idea that, well, if someone's rights are at stake, just because we can't find the right place doesn't mean we should abandon those rights. And the problem with that, which we'll get to probably here in a little bit, is it cuts both ways. Because if the pro-life side can't, if we can't justify why 15 weeks is any better, well, still, it's not a line that's clear, but, liberty's still being protected.
Yeah, and beard fallacies do happen sometimes, and pro-life people make them sometimes. We have an article on this called "Avoiding an Embarrassingly Common Pro-Life Mistake." Tim will drop that link in the comments. Like pro-lifers should be careful to avoid fallacious arguments like beard fallacies, but obviously not all pro-life arguments are beard fallacies. Emily, did you want to talk about kind of the argument that was made about like this is, there's this really big difference between viability and drawing the line 9 weeks earlier at 15 weeks?
Yeah, so I think within this big conversation about where should the line go, are all of the lines arbitrary, the pro-choice lawyers obviously don't want the line to be put at 15 weeks. They seem to be very happy with it at viability, or at least that was the arguments that they were making. And so they were trying to argue that the moving the line back to 15 weeks, that's, I mean, essentially 9 weeks earlier. Viability is currently considered to be 24 weeks. And so that's 9 weeks earlier than they were, currently being allowed to have abortions. And so they were essentially making the argument that we can't move that line back because that will hurt a lot of women in the process. Like, they're both kind of arbitrary lines. They weren't able to really defend why viability is a good line, but it definitely shouldn't be moved backward to another arbitrary line because so many women would be hurt in between the two arbitrary lines. Essentially, people will have job changes, or their health will change, or their partner will leave, or there's all sorts of different things that could happen that's going to change their life in that 9 week period. And so that's a crucial 9 weeks for women, and we shouldn't be just moving back the line arbitrarily when it would have such an actual real life effect on all of these women. That was essentially their argument, which Alito jumped on, which we all got very excited when he did that, because basically what happened was the pro-choice lawyers were acknowledging that women need abortion after 15 weeks for all these different reasons: job change, health change, relationship change, all that kind of stuff. And Alito pointed out that all of those changes exist after viability as well. Like, women still hypothetically would need abortion for job change, health change, relationship change that happened after viability. And so to say that those things can happen between 15 weeks and viability, and that's why we shouldn't move the line, isn't really an effective argument, because after viability, they could have all those changes too. So if that argument's true, then we should just have abortion available all 9 months of pregnancy, because those changes will always happen, which I think is ultimately why the pro-choice lawyers were trying to avoid explicitly saying they're grounding it in a bodily autonomy argument. They weren't really grounding their argument fully in bodily autonomy, though they were throwing around words like liberty, because it does create that problem that Alito pointed out, where if you're going to try to justify abortion at one time based on bodily autonomy, you have to be able to justify it for all. It was an epic moment. Alito just had some amazing little back and forths with the pro-choice lawyers throughout this whole thing. I feel like that's been a theme here. Alito said a lot of epic things, so this was definitely one of them.
The thing that I observed about the exchanges of with the pro-choice counselors about like the idea of a 15-week abortion ban, like they kept on talking about like, well, there would be this big problem, like, but most women who are having 15-week abortions, they need them the most because of job changes, health changes, relationship changes, like all these different things. But I noticed like they were never making the claim that a lot of pro-choice people do, that late-term abortions only happen if there's a significant problem with the baby or the mother's life is in danger. Now, sometimes like pro-choice people might be meaning late-term abortions that are later than 15 weeks, but a lot of people like basically would consider like second and third trimester abortions to be, in this later term category. It's like a lot of pro-choice people think that anyone who's not having a first trimester abortion, they're having it because like they really wanted the baby. There's this huge problem. The baby's got anencephaly and it's going to die anyway. And so like, let's just try to make things easier for the mom by having an abortion, which I argue is not actually better for the mom anyway, but that's also not the most significant point. That doesn't justify killing. But these pro-choice counselors never claimed that even most of the abortions at like post 15 weeks are these kind of inelective abortions. All the reasons they were saying, like, this is why women need abortions between 15 and 24 weeks, they were all elective reasons. And that would be a talking point that pro-life people can use. Because remember, like, the more times that you can quote someone on the pro-choice side, the better. Both of the pro-choice counselors defending abortion to the Supreme Court in the most important Supreme Court abortion case in 30 years since Casey were both functionally conceding by a lack of a statement otherwise that at least some late-term abortions, at least some abortions between 15 and 24 weeks are elective procedures. Andrew, so we need to get to Q&A pretty quickly, but real quick before we do any kind of quick predictions, Andrew, talk about the kind of the middle ground position problem.
Okay, so if you remember all the way back to the top of the stream, I mentioned that the original argument that the state was making was that you should undercut the viability standard. So you can keep Casey intact. You don't have to overturn Casey, just throw out the viability part. And then added on the argument, well, maybe just overturn Roe and Casey, and kind of made that the main argument. Well, the problem is the pro-choice side contends, and Casey makes this claim, that the right to abortion up until viability is the central holding of Roe. And that's in the words of Casey. And the pro-choice lawyers are standing well on that kind of case. And so there's this idea, and it goes with the legitimacy question. Can you craft some sort of a middle ground decision? On one hand, we could strike down this law. We could uphold Roe, uphold Casey. Done. On the other hand, we could overturn Roe, overturn Casey, uphold the law. Is there something in the middle that works? Is there we can uphold the law, but also leave Roe and Casey more or less alone? And so the counsel for the state is arguing, yeah, sure, you can do it, kind of, maybe. It would be some sort of application of undue burden, but without the viability standard attached. Pro-choice counsels argued that viability is part of how undue burden works in Casey, and so you can't just jettison it. They're kind of right. But also, as I was explaining with undue burden, this isn't creating a burden, it's a ban. And so now he's suggesting that it's going to be a clearer, more workable thing than the current viability standard, which is problematic. He's arguing is more problematic than maybe it is in enforcement cases. But he's trying to argue that it would be more clear to have undue burden on abortion be the standard for evaluating abortion bans before viability. But a ban isn't a burden, it's a ban. And so he admits in his argument that it's not really that workable, and so you should just overturn Roe. And the pro-choice counsels argue, if you reject viability, there isn't an alternative. There's not a more principled line. This one has precedent. And if you reject it, you have to overturn Roe and Casey. And so there's this interesting kind of crystallization that hopefully is happening. I say hopefully because there are three possible outcomes, and I want the outcome that overturns Roe. I don't want the outcome, it's not the worst outcome, but I don't want it, in which there is some sort of larger majority that upholds this narrow ruling in which the law is upheld, but Roe is still the law of the land. So if that option is kind of removed, then it's either uphold Roe or strike down Roe and uphold this law. And it seems like Roberts was casting about for some way to save this middle option, and no one believed this middle option actually existed, which is really going to affect where the justices end up, I think, because the desire to carve out the middle legitimacy stability route may not be practicable.
Okay, before we jump into Q&A, does anyone want to share any predictions? I'm willing to go first on that because I know a lot of people have been interested in just kind of people who have been paying attention to this. What do you think is going to happen? Then we'll jump into Q&A. I'll tell you, David French has been very convincing to me on this. I agree with David French a lot of the time, not all the time, but I really like him. I love listening to his podcast. I was with him like 3 months ago when he was saying, I don't think Roe is getting overturned. You see, his view, when in the Advisory Opinions podcast with Sarah Asker, where they kind of do like Supreme Court nerd talk, basically. If you're into Supreme Court stuff and you want to hear thoughtful conservatives who are not like, hardcore right-wing people talk about that stuff, this is the podcast for you. And they felt like pro-life's probably going to win. It's a question of how big of a win is it going to be. And the thought of like maybe second, third trimester abortions are banned, or maybe that line goes back to something like 15 weeks. Like that seemed the most likely then. And that seemed likely to me too, given where Roberts has pretty obviously been for a long time. And also, I've been always convinced, I've said this publicly, I've quoted Clark Forsyth from AUL a lot of times on this, who wrote in a book a long time ago. He said, like, Roe is probably not getting overturned in a 5-4 decision. This is going to be at least 6-3, because overturning Roe will be the most controversial thing to happen on the Supreme Court in 100 years. No one's going to want to be the fifth vote. No one's going to want to be like the Kennedy vote on that and the swing on something that controversial. And that has made a lot of sense to me. Having said that, if you listen to the Dispatch podcast, just like, go listen to all the these. They've got multiple podcasts. I was listening to Jonah Goldberg's on the way here. I don't listen to these all the time anymore. I've been kind of taking a break from politics for the most part this year, and that's been really good for me. In social media, it's been really good for me. But I was super interested in what they had to say about Dobbs. And so David's position yesterday, and he kind of talked about this a little bit in an article today, is pretty persuasive to me, and it's optimistic. He has become more optimistic, not so much Sarah, but David has become somewhat more optimistic now, based on, and I couldn't explain this as well as him, so go listen to yesterday's Dispatch podcast where they talked about this for like the first half of it. But he explained like the way that the Supreme Court decides what cases they're going to take. Like, there is strategy involved. Like, you need 4 justices to agree to take a thing. And so for at least one of the conservatives who have been like on the side of taking this case is significant. So it seems like you've got kind of like these 2 most obvious options. Like there's technically a third option where they don't do anything and they just kind of uphold the Casey standard, which seems like the least likely. Like at this point, that's not what anyone's betting on. Pro-choice people would like that to be the case, but that's probably not what's going to happen here. So either you're probably going to end up with a 5-4 decision to completely overturn Roe and Casey, or you're going to end up with a 6-3 decision where Roberts joins the majority on a narrower victory. So it would be something like, they drop the viability line, they drop that down to 15 weeks, but they try to keep undue burden, or maybe they let go of undue burden, but at least, abortions can be banned after 15 weeks, or like just some narrower thing. Like that's going to be what Roberts is going to be wanting to make happen. Whereas it seems kind of like the 5 other justices arguably are more at least willing to say, look, yes, there's precedent, but this is an egregiously badly decided case. Let's bring things back to a neutral position. And something that David wrote in the article, I like. He kind of said, like, look, a lot of times Supreme Court judges don't want to do shoves in a certain direction. They want to do a nudge. They want to like keep things more incremental. But in this case, people like Barrett and Kavanaugh and Alito might feel like, okay, yes, typically we would rather do a nudge than a shove, but in this case, the left shoved first. What happened in Roe was a huge shove. That was not the situation before. And then they completely rewrote all the abortion laws in all of the states based on made up, lines and principles and rules and things like that, definitions even. And since they shoved first, maybe they'll be like, hey, in this case, it is, right to do a shove back in at least a more neutral position. So I am, for the very first time in my life, I've been fighting abortion for like 20 years now. For the first time, optimistic that Roe and Casey might get overturned in like the next year. I hope David's right and Sarah Isgur is wrong, because he's definitely less optimistic, but that's where I'm at right now. Andrew and Emily, do you have any predictions before we jump to Q&A?
So I'm generally not Team David French as much. One thing that kind of accords with his analysis, if they accept a 15-week or some other middle ground thing, they need to be able to stake out a clear line. Otherwise, they're going to be deluged with new lawsuits. So thinking about the heartbeat bills that were being written a couple years about that we covered, I believe it was Missouri's, where they just had a series of clauses where they're like, okay, so we're going to ban it at 6 weeks. And if you don't like that, we'll ban it at 8 weeks. And if you don't like that, we'll ban it at 10 weeks and 12 weeks and 14 weeks. And that's what's going to happen. If they don't give some sort of clear line, and no one believes that there's actually a clear line that they can give, then they're just going to be hit with lawsuit after lawsuit, as they should, until they can give a good answer. And I don't think the justices want that. I don't think they want to be litigating abortion on an annual basis for the next decade. And that pushes it more towards either a reaffirmation, which would be, I think, a super crushing defeat. I think it is understated and underestimated how crushing that defeat would be for the pro-life legal efforts, or overturning Roe. My only prediction is that you should not trust the court. I've written about it. Don't trust the court. Don't trust Roberts to do what you want him to do. Because those 9 people, as much as they sometimes come across as disliking each other, have more in common with each other than they do with any of us. And they're going to make a decision for the reason they make a decision. And that we can do something about it. You know, the 100+ amicus briefs, the oral arguments, the work by all the lawyers. But at the end of the day, Roberts is going to make his decision, and 1 or 2 other of the Republican judges are going to decide how this case goes. And I don't want to bet that Roberts and Gorsuch are going to go with the party line, because they've both defied it in the past.
Yeah. It'll be interesting to see. Okay, let's jump into questions. We've been going for an hour and 45 minutes. That's longer than we meant to do, but there is a lot to cover. So let's jump to questions. Tim Hull, again, if you weren't here in the beginning, Tim Hull is a good friend of mine. He's a Christian apologist, and he's really good at running live streams. And he will be moderating all of our live streams forever, because I hate running the software, and I've done it like a dozen times, and I've had a different problem every single time. And Tim just knows how to do it well. And so I'm just happy that he's on. So Tim, give us some questions.
I'm so happy to be here as well. And I do want to point out, my goodness, your amazing wife said that Tim should get a tip for all of these articles that are dropping in there. So Hannah, thank you so much. I appreciate that.
I'm buying the coffee next time.
Right. That sounds great. So we have kind of 2 primary questions. If people have questions, go ahead and drop them in the chat quickly as we're kind of answering some of these. And one question is really long, so I'm going to do my best to try to read it the best I can, but we'll start with the shorter one that came in first. Brian Freeborn, actually, we were joking in the chat that he, for the first time kind of made a connection that his last name was very pro-life, to be free to be born.
Yes,
but so he asked, do you think it is coherent to say that once a fetus is viable, ignoring the moving target issue, a woman no longer has the right to kill her fetus, since there is now the option to induce labor? So similar question to, I think, what I asked when I jumped in. If you want to just brush over that really quick, that would be great.
Emily and Andrew, you want to go first?
I can.
I guess
not. I can. Yeah, jump in.
There's too many people answering questions.
Yeah, so I think there's an idea that my colleague Rachel used to talk about as the pro-choice position as not being a right to end pregnancy, but a right to a dead baby. And that plays out with, for example, that not being something that's actually pursued almost ever. Like, it's something that we can't name as having occurred, early delivery for the sake of ending the pregnancy. And it's shown in the ways that the fetus is treated differently, depending upon whether it is intended to be destroyed or whether it is intended to be delivered. And the different standards of medical care that occur even after viability, depending upon what people are wanting to choose for that child. And so coherent, probably not. I would say no. I think the sorry, can you put the question back up, Tim? I lost my train a little. I think that would be more consistent with the rights to end pregnancy. And that's maybe the difference between a sovereign zone style bodily autonomy argument and a right to refuse bodily autonomy argument. So I think the right to refuse position would say definitely you can unplug, you should unplug, you no longer have the right to unplug in a more violent manner. But the sovereign zone position says, well, no, it's still within your body. You have the right to do whatever you want within your own body. And so that's the two different pro-choice understandings of bodily autonomy also complicate that.
Yeah, when the viability thing, like obviously pro-life people would rather have abortion banned after viability than not banned at all, and they could certainly make a claim. It was like, well, look, if as once the baby is able to survive outside the woman's body, look, just don't kill it. Let's just move it into the NICU ward. It's not persuasive to that many pro-choice people for the same reason as the pro-choice counselors yesterday morning said, yeah, but that doesn't solve the bodily autonomy problem. Like a lot of women don't want to have a C-section. If they have a C-section, they want to be the one like choosing it for themselves, or if labor is going to be induced, they want to be choosing that for themselves. They don't want a law saying you've waited too long, you can't have an abortion now. Like they want, if not absolute bodily autonomy, a very significant amount of bodily autonomy that trump the baby's right to life at functionally any point in the pregnancy. So it doesn't end up being that persuasive of a move, sadly, because of that. By the way, just because we always like to try to credit sources, I think it's Hadley Arcus who first argued that difference between our pro-choice people arguing for a dead baby or ending a pregnancy. And on that note, I meant to jump in earlier, and I totally forgot. I lost my train of thought reading the comments. But on thalidomide, so we talk about thalidomide. The first thalidomide point that we make, we are quoting Dr. Rich Papard on that, who's the first one to use thalidomide in a pro-life argument. But then we've got a spin on it. That we teach in the Equip for Life course. So, Tim, if you haven't posted the bodily rights landing page yet, post that, because bodily autonomy is huge. You can see how big of a thing it is in even the Supreme Court arguments yesterday, and we have a bunch of resources on that. Certainly, some of it's in the Equip for Life course, which you can purchase, but also we've got a bunch of articles and videos out for free that you can start to dig into that topic.
Yeah, I'll go ahead. I might have posted it earlier, but I'll post it again here in just a second as we're answering this other question. This one's a long one, so I'll do my best to try to read it here. Here we go. So it literally covers up most of the screen. So I apologize. This is not my normal, but it's really long. Okay, it says, okay. When asked about late-term abortions, most pro-choice people argue that they are strictly for serious health and fetal abnormality reasons, which isn't true, or that they're essentially too rare to actually matter. They're only rare because there's lots of early abortions. 1% of all abortions adds up to 10,000 per year. But the more clear abortion advocates argue that pro-life now I lost my spot. The more clever abortion advocates argue that pro-life people don't really care about late-term abortions because they oppose an early abortion, and inability to access early abortions is the predominant reason why women have later abortions. Interesting point. Some even say that they would be willing to support a ban on late abortions in exchange for making first trimester abortions more easily available. European countries have meaningful gestation limits, but none of them have a Hyde Amendment, for example. What would be the best way to respond to this? I point out that it would be akin to legalizing type 1 female genitalia cutting in order to reduce type 3 female genitalia cutting, which is worse than type 1. Any thoughts? So,
yeah, I'll jump in first, and Andrew and Emily, feel free to add if you want. So just for those who aren't familiar, with the thing on female genital mutilation, there was actually an interesting debate among I forget what group is like the American Association of Pediatricians or something like that. I don't think it's the right name, but it was like, one of these kind of big associations of pediatricians, and there's a debate that happened about female genital mutilation because an increasing thing was happening where, while typically this is a thing that's only happening at this point, like in certain tribes, in other countries, more and more people from those areas were immigrating into America. And because female genital mutilation, it was considered kind of like this important ritual as like for their traditions, as part of their tradition, they were still wanting to do it, even though they are now living in America instead of somewhere else. And so obviously sometimes this is happening inside people's houses, which is horrible. But then sometimes parents were basically bringing their baby girls to a pediatrician saying, we want to do female genital mutilation. And so some pediatricians for a while were kind of doing this thing where like, okay, they were kind of compromised and they would do this type 1 thing where they would only make kind of this small cut that isn't nearly as damaging in the long term versus type 3 where you're, often removing the entire clitoris or something like that. And just like major mutilation. And so some doctors were considering this like kind of a clever way to appease these parents that still care a lot about this tradition, while at the same time harming the girl less. And so if memory serves, for a few years, the official position of this association was that you could do this in order to harm girls less. And then that got reversed when kind of it came out and more doctors were saying, no, it is like, this is not a compromise. It is wrong. It is morally wrong to mutilate, these little girls' genitals for no medical reason, even if you're doing it in a less significant way. And so I'm pretty sure basically they reversed that and they've banned that practice. So just the background on what's being asked. So let me just kind of work through Jack's question. So. Yes, most pro-choice people argue that they're strictly for serious health fetal abnormality reasons, or that essentially they're too rare to matter. I agree that that's true. But as far as pro-life people saying like they don't really care about late-term abortions because we're opposed to early abortions, like that's true. If pro-life people basically are only arguing about late-term abortions publicly, but privately they're against all the abortions or most of the abortions, then sure, that can seem weird to pro-choice people. But I think you can legitimately say, like, for us, like in our dialogues, one of the first questions I'm going to ask when I'm trying to find out where a pro-choice person is what do they think about late-term abortions? And the reason I'm asking that is because I'm trying to get a sense of what their view about abortion is instead of assuming. And I made this point on our podcast. I don't remember which podcast episode, but Emily might. And if Emily does, she can let Tim know which episode. But I made the point, like, there is a legitimate thing when either side asks each other about extreme cases. So I think it's legitimate when pro-choice people ask us about the case of rape, like in the beginning of the conversation even, just like I think it's legitimate for us to ask about late-term abortions early in the conversation. Because in both cases, sometimes what's happening is we are exploring the other person's view, in my mind, like a cartographer, like a map maker, where you're starting with the boundaries and then kind of fleshing out what's going on in the middle. And so asking about extreme cases first is kind of a quick way to kind of get a sense relatively fast in the conversation. Where is this person? How extreme is their view, etc. Now, of course, I know some pro-choice people ask about rape because they want to kind of get you on the defensive really fast. Okay, sure, that happens sometimes, but I think a lot of times it's just a legitimate question. So that's what I would say about that. As far as the compromise, I wouldn't be okay with a compromise that where like pro-lifers are basically signing off on legislation that makes it easier to access most abortions, the first trimester abortions, in exchange for banning, like let's say second and third trimester abortions. I wouldn't be for that because while I'm definitely okay with incremental legislation, I don't think that we should be like basically justifying in the law any abortions. Like I think you can have a ban on late-term abortions without saying we're okay with the first trimester abortions. But I think saying we're okay with the first trimester abortions, even for a compromise, I wouldn't be okay with that. But I also don't think that's the compromise that would happen. Like I think it'd be more likely, arguably, that when Kamosi and Beyond the Abortion Wars, he talks about an interesting idea of a compromise where we ban most abortions in exchange for like some other like really significant wins on the left, like serious maternity and paternity care and some other things like that. Although, frankly, I'm on board with that one. But I think he had like a few others on there too. Like you could see theoretically something like that happening. But at this point, everything is so partisan. I don't think you're going to see either of those things happen anyway. Andrew and Emily, do you want to add anything to that?
Yeah, I think just kind of zeroing in on the European laws that was brought up in this specific question. I pulled it up on my side of the screen, but maybe Tim can throw it back up on the main screen here. He mentioned that European countries often have some sort of meaningful gestational limits, but it's much easier to access abortion there, which I do want to highlight that as being true. And I did all that fact checking earlier. If you were on the live stream earlier and you heard about my epic fact check of the European abortion laws, it is true that while a lot of them have that potentially nominal, we'll call it ban earlier on, they do usually have it extremely accessible to have abortion, far more so than we have in the United States. You can get it at any hospital, just go to the doctor, get it in 2 seconds. There's very rarely some sort of waiting period or anything like that. Sometimes there is, but it's really, really rare. And so the idea that we could adopt something like that in the United States has been brought up by many pro-choice people, and it was brought up very briefly by the pro-choice lawyer in this actual case, but mostly then she went back to the argument that they're really just nominal bans in the first place. But I've heard many pro-choice people suggest the idea that I'd be okay with having an earlier restriction on abortion, but we need to have it just as available, accessible as it is in Europe, where anyone can get it, and there aren't these just barriers there. But as Josh said, not only do I have an issue with that because it's still not actually focusing on what is happening, that this is the killing of a human life, and so I don't want to be compromising around that in the sense of saying like I'm okay with saying like, oh, we'll just make it more available in this time so it gets rid of it later. So I'm not okay with it from that perspective, but also I don't think it's literally possible because of how partisan we are. But I just wanted to highlight that kind of fact-checking piece of it. Is true that in European countries it is usually easier to get it despite the earlier gestational limit.
Cool. Well, let's go. We got one last question. Man, you guys are troopers. We're 2 hours in. This is fantastic. So Rebecca asks, I'll go ahead and put this here. Rebecca asks, if the court overturns Roe and leaves it to the states, what will the most likely path be from there to a federal ban? Would Dobbs' precedent of neutrality make it harder to get the court to later rule that permitting abortions is unconstitutional? Are there other likely paths to the federal ban apart from the court?
Yeah, that's a really good question. So here's my take on that is that if this goes back, oh wow, what are you doing? No tips for Tim.
Yeah, Hannah already, she revoked my tips because
Oh well. I think if the court overturns Roe and Casey, there is a lot of work for the pro-life movement to do in multiple areas. First of all, we need to get a lot better, both in the way that we talk and in the way that we actually do try to support pregnant women. So certainly the pro-life movement does do that to some extent. Like pregnancy centers are huge. There's over 2,000 of them offering, it's like tens of millions of dollars worth of care for free to women who are pregnant. And not just women who are pregnant, women who've had their babies. Like we continue to help them. Like this myth that we only care about, fetuses until they're born and then we don't care anymore. Pregnancy centers prove that wrong. I've spoken for a bunch of them. Typically, before I speak for them at a fundraiser, I tour their facility, and like all of them are providing care years after birth. Okay, so pro-choice people are just factually wrong about that. It's a myth. But we do need to get better, and I think there are social policies and things that can be that we should just be willing to go with to give more resources, even tax dollars, to support women who are pregnant and would be abortion minded or abortion vulnerable. Like this is going to be an area where I'm going to be like, yes, let's figure out ways to support these people as much as possible. And certainly churches can do a better job, generally speaking, of helping the women in their communities who are having an unexpected pregnancy or something like that. Certainly there's going to be a big legal battle at the state level, right? So again, you've got something like 15 states with pro-life trigger laws right now. You've got 15 or 20 with pro-choice trigger laws. You've got the Freedom of Choice Act in the California state constitution, for example, that's functionally like, abortions are completely legal, no matter what in our state constitution, regardless of what happens with Roe versus Wade. And then you're going to have, something like 20 states where there's going to be more of a legal battle because they don't have like a trigger thing. And so it's going to be a question of what is their law going to be? Is there going to be law going to be, only allowing first trimester abortions and banning after that? Is it going to be the Kaake thing of this legal until viability? What is that going to be? There's going to be this kind of state battle going on. It's going to be really, really important for pro-lifers to be ready to make good arguments because like right now, and not to continue to quote him all the time, sorry, Andrew, but as David Francis noted, like, unfortunately, for a lot of Americans, abortion is less salient of a moral issue to them right now. For example, a lot of, evangelicals who voted for Trump, it has been shown through polling, cared more about the immigration issue than the abortion issue. That's not good news for people like me who want to keep abortion, as, not the only issue that matters, but certainly a very, very important moral one that we should continue discussing, continue debating, talking about, passing laws on, etc. And so we're going to have to get better at dialoguing about abortion. And I think we're seeing, not to pat ourselves on the back, we're seeing a lot of really cool things at ERI with the people that we're training who are getting much, much better at dialoguing in ways where they're actually seeing pro-choice people change their minds. So subscribe, get the emails, look at the blog, get the Equip for Life course if you want a more systematic approach to the most, persuasive arguments that we have found to work. And what was the other thing I was going to say? Let me think for a second. And I think the other thing is, I don't think at that point the Supreme Court should end up weighing in again. I think the end goal here is a constitutional amendment that makes clear that the unborn count, that the unborn are persons. You might also need a bodily autonomy related ruling too, but I think I'm currently on the side that this shouldn't be a Supreme Court issue. This should be, ultimately a constitutional amendment. I think there are a lot of things that ought to be left to the states, but I think cases that are so significant, cases where if pro-lifers are right, then millions of babies are getting killed. I think that's a significant one. It's in the same category as slavery. Like, we shouldn't leave slavery to the states. Ultimately, the 13th Amendment should be a thing. There should be a thing that kind of says, we're not doing this anymore at the federal level because these are persons and they should have the right to liberty. Or they have the right to liberty that has been ignored up until recently. And so I think ultimately that's what happens, but that might take a lot longer than Roe just getting overturned. Like, our society might have to change a bit before that becomes possible. That could be decades away, I think. I'm open to being wrong. Again, I'm not a, political strategist, always paying attention to every senator and every congressperson and all the stuff going on. Frankly, I've had to take more of a break from that this year for my own mental health and just focus on pro-life training and dialogue tips and all of that. But those are basically my thoughts on that. Andrew and Emily, is there anything you want to add to that before we wrap?
The quick political kind of take is, so I agree with you, Josh. I think that this has to be a federal issue at some level. The Lincoln-Douglas debates, Lincoln argued, no, we can't let the states vote up or down because you vote up or down on things that aren't grave moral evils. Abortion is a grave moral evil. You don't vote on whether it's okay to do a moral evil. And so The question is partially about a federal ban, and that's a tricky thing because that means you need a functional legislature. We don't have a functional Congress right now. And until we get to a point where we have a Congress that can function or that has the political will, because our Congress, when the Republicans had the majority in the House and the Senate, did not have the political will to pass the Born Alive Survivors Protection Act. That's an active record. And so until you get to that point, a federal ban is not likely. The Congress could have passed a law at any point. Little known fact, you can just ignore the court if you're another co-equal branch of federal government. In the way that Obama declined to defend the Defense of Marriage Act, a sitting president could decline to defend Roe in court, for example. Or the Congress could just pass a law because they can do that. But that's not really what's happening. The one thing, so I probably think it's appropriate for the court to rule the anti-Roe decision, the personhood is in the 14th Amendment, you don't get to have abortions. However, by the nature of judicial philosophy, conservatives tend to advocate judicial restraint, whereas liberals tend to advocate judicial activism, which means conservatives are not willing to take that huge step and just change the law. That's not something they're really open to doing. And I think to their detriment in this case. So the best chance for a federal ban is, I think, a federal law, which is subject to change, but it's hard to repeal a law. I don't know that a constitutional amendment is in the cards because of the supermajorities that requires. But a law you can at least pass if you have control. It's been done on things that are far less momentous than abortion. So,
Emily, any thoughts?
I think this whole question really just highlights what Josh already brought up, which is the importance of dialogue and how much more important it's going to be after this case comes down. Regardless of what is decided, this is going to be a huge issue that's going to be talked about everywhere. And if either Roe is overturned or the kind of middle ground option where we end up with a 15-week potential ban that states could do in any state in the country, we're going to have a much more localized conversation. Whereas right now, in the minds of many pro-choice people, this is a settled issue. And if suddenly the Supreme Court proves that this is no longer a settled issue, all of the pro-choice people who weren't already having these kinds of conversations and wanting to actively defend abortion are suddenly going to be having those conversations in your daily lives. And this makes it all the more important for pro-life people to have effective ways to talk about this with their friends and their coworkers and in their classes, because this is going to be a much bigger national conversation when this ruling comes down, and an even bigger conversation if it comes down on the pro-life side.
Yeah, excellent.
So get ready before June. Get ready.
Well, man, thank you guys so much for this conversation. You can tell that you guys are passionate, you're educated, and I love that. I loved being kind of a fly on the wall in the background and helping in any way that I can. So Emily, Andrew, Josh, thank you so much for this dialogue. I loved it.
Thanks for moderating, Tim. You are the man.
Well, with that, we are going to wrap up. If you enjoyed this conversation, you would definitely want to subscribe to the YouTube channel for sure. For checking us out on YouTube, go ahead and click right over here and subscribe. And you might also like this video over here to check out in the future. And with that, we will see you on our next live stream when we are going to continue these conversations because they're extremely important. So thanks for joining us. We'll see you next time.